Naval War College Foundation, powered by its generous members and donors, provides critical funds needed to support the college's unique ability to develop military and civilian leaders who are skilled in the strategic and operational challenges that lie ahead, are dedicated to preserving our national security and global position of leadership, and are adept at navigating the challenges of war and, most importantly, the prevention of war. We are particularly thankful for the Naval War College Foundation's many Heritage Society members who have provided generous estate plan gifts to support the mission of the Naval War College Foundation and its mission to sustain an academic experience at the college that is focused in three principal areas: military preparedness, leader development, and diplomacy and statesmanship. Heritage Society members are prominently recognized on a plaque in Spruance Hall on the Naval War College campus located in Newport, Rhode Island. Like many planned gifts, membership in this Heritage Society and similar programs helps to sustain the college for posterity. Therefore, I'm extremely thankful for your time and attention this afternoon. The Naval War College Foundation is pleased to present the seminar for our valued members and donors who value our national security and the many freedoms we enjoy today in our great nation, and who want to learn more about how planned giving will not only leave a legacy in the area that is of great interest or concern to them, but also benefits a world-class institution charged with developing military and civilian leaders who have taken an oath to protect our national interests and way of life that will benefit our children, our grandchildren, and our great-grandchildren. I want to now introduce your keynote speaker for this afternoon's seminar, Mr. Eric Archer, a Rhode Island lawyer with 35 years of estate planning and planned giving experience. He has served as the Director of Development for Roger Williams University and for the Naval War College Foundation. He continues to advise the Naval War College Foundation as well as Salve Regina University and other local Rhode Island charities on tax and planned giving matters. He's a graduate of Colgate University and UConn School of Law and now practices with his wife, Deborah Foppert, at the firm of Archer and Foppert, LLP, in Jamestown, Rhode Island. Following Eric's presentation, we'll have a short Q&A session, so should you have a question, please hold it until after Eric's presentation, and he'll try to address it as many of them as time permits. Ladies and gentlemen, without any further ado, please give a warm virtual welcome to Mr. Eric Archer. Eric, over to you.
Well, thank you, George. I am going to blast through like a used car salesman speed, a slide presentation, and hope to get done in hopefully a half hour, and leave plenty of time for questions. If something pops up, feel free to go ahead and unmute and interrupt me. I'm pretty good at getting back on track because this is pretty much what I do day in, day out. And I say the same thing to a lot of people a lot of times each week. So have the same jokes and, tweak them over the decades. So why don't we go to the first slide, 5 key elements of an estate plan. This will be the outline of the later parts of the talk, and there's going to be basically one slide for each of these categories, with a couple others in between with some important points. But these are really the 5 documents, 4 or 5 documents that a couple would walk out of a estate planning signing ceremony with. They are the financial power of attorney, a will, or a trust. And I'm going to go back and forth between talking about wills and trusts, but both of those are the document by which assets pass upon your demise. In order to understand and carry out the terms of a will and a trust, you also have to know how your beneficiary designations on various assets relate to those. And that would include any charitable beneficiaries. And then the third and fourth set of documents are healthcare documents. There are 2 types. There's a HIPAA form and a healthcare power of attorney. So that list is pretty much the package that a person that does an estate plan would hopefully leave with, because it covers both what happens during life in the event of incompetency and what happens on death. So go to the next slide. Financial power of attorney is often one of these very similar. One person's is a lot like another's. In some cases, it is the most important piece of paper a person signs. And when I say there are various flavors of a power of attorney, all of them do the same basic thing, which is to allow somebody to step in to take over the management of the financial affairs of somebody who loses competency, and Sometimes they're even handy for just people who are busy and they want to leave somebody the power to carry out a particular undertaking. And sometimes, one spouse is in one country, another in another, and often have appointed each other, and they're handy for that purpose. For the most part, there's very little deviation from one person's to another, except on the points that I'm going to raise here. So a lot of states have statutory powers of attorney, where you say, look, I just want to set up a power of attorney under Florida law, and using that language incorporates automaticely, 2 or 3 pages of statutes in the law books that anybody could look up, but it basically boils it down to which way a person wants to go on these questions. Those powers of attorney that are not statutory are just all spelled out. So it's either in the document or it's in the statutes. But either way, the questions that really change from one person to another are whether it's durable or non-durable. And the only difference between those two is, does this cease effectiveness if a person becomes incompetent? Given the purpose of these things, most of them are durable. So non-durable is almost a non-existent category. The next category is important, springing versus immediate. So if you were in the services and you were to go to the JAG and say, I'd like to set up a power of attorney, the default provision is the springing power of attorney. It only becomes effective if you become incompetent, because the worry is, that possibly newly married spouses go off overseas and all that, and it's kind of worrisome to have a power of attorney that is effective, right away. So a springing power is for a situation where there's any worry that you wouldn't want to have the power exist unless there's a reason it's needed. For 20-year married folks, usually it's an immediate power of attorney where it doesn't have to spring into existence upon incompetency. It is effective from day one, in which case one of the safeguards you have is, where do you keep the originals of this thing? Because you can't do much with a power of attorney unless you're holding on to the original. Some attorneys have a form that says, here's what I'm doing, hold on to this, and these are the circumstances upon which I would turn this over if somebody calls me asking for it. And usually the attorney will do a stress test to make sure that the reason that somebody's asking them to send the original power of attorney is a legitimate one. And the last difference between one person's and a power of attorney and another is whether or not the form gives the power to make gifts. Most would at least allow a power of attorney, the attorney in fact, to fund a trust. It's a very important purpose of this. You can use a power of attorney in sort of the late stages of a person's life to try to get everything into a person's trust to avoid probate. More often than not, they will also give a gifting power, where if a person has appointed a spouse or even a child to be the attorney in fact, which is the agent who is appointed under a power of attorney, you might give that agent the ability to make gifts, including gifts to him or herself, which can be critically important for tax reasons, sometimes for some people, there are situations where you can use them for Medicaid eligibility purposes. So most powers of attorney would have a gifting power. And a specific allowance that the person who holds that power can even make gifts to him or herself. Some will say no gifts for whatever reason. And most will also allow for charitable gifts. And sometimes charitable gifts late in life make a lot of sense for financial reasons. So we'll go to the next slide. Next document that most people have is a will or a trust. And wills, trusts, and beneficiary designations, co-ownership, all combine to define where assets go to a person, go upon a person's death. And trusts would be a whole separate seminar, or about the same amount to talk through the different kinds and types. But I think it is important to know that the order of operation of what controls over what is that anything that defines what happens to an asset on a person's death overrides whatever a will or a trust says. So when my item number 2 here says ranking of will and will substitutes, and I'll be talking about will substitutes on the next slide. But if you have a joint account and you say, I leave my joint account to somebody other than the joint owner, that's absolutely meaningless, because the joint ownership is what will control the destination of that particular asset. Same thing with IRAs or life insurance or whatever. If your life insurance policy says, I leave this to my daughter, and your will says, I leave my life insurance to my children, all 3 of them, it goes to the daughter. So one of the things that we as estate planners always sort of, try to be doubly careful about is that we haven't set up this whole estate plan that has a bunch of provisions in it that are all entirely overridden by something else that exists outside of our line of vision. Because beneficiary designations control so much of a person's financial life, the typical scenario for a couple is that the will has very little over which to operate. Most couples will have an IRA that names each other because there's a financial incentive to do so. They would own their real estate jointly. They would be sure to have life insurance name each other, and then the contingent beneficiaries may be their children or somebody else. So wills often focus on what happens when the second of a couple dies, if it's a will for a couple. And often one of the questions that an estate planning attorney is trying to really get to the bottom of is what isn't joint, because that's what's going to go through the will, and anything that goes through a will has to get to the person it's going to by probate, which is a conversation we'll talk about in the next slide. There are 3 sort of stages in the typical evolution of a person and times at which they review and update their estate plan. This is my point number 4. You'd think there would be 4, but there's really only 3. You'd think that when a couple gets married, they do a will that says, I leave everything to you and all that. That doesn't, I guess it happens. I don't see a lot of newly married people coming in here and doing their wills, but people almost invariably think about doing a will when they have children, because it's the document by which they would name potential guardians and trusts for their children and all that. So there's sort of the new children trigger. Then there's the old children trigger, later in their life and career, and their children have grown up or haven't. And they decide whether or not to bring the children in as the actual fiduciaries that are named in the document. Do you name your kids as your executors at some point? A lot of times people name their siblings as the guardians and the fiduciaries if it turns out that the surviving spouse isn't living. But then later in life, in their 60s, 70s, their children are all on their own and launched, and usually one or the other of the children sort of has identified him or herself as a good person to be named for these financial and other roles. So one of the things that we spend a good deal of time of is talking about these fiduciaries. Point number 5 here. Who is going to be the best executor or trustee selection? It's an organizational task. Often there's not that much discretion that a particular executor has to do other than carry out the terms of the will, get the assets where they're supposed to go. And, the category of people and charities that will get assets in the event of a death is kind of the topic of the later part of this conversation. And I usually encourage people to think of which of their children would be the most likely to be able to get things into QuickBooks or that type of step. The only point at which an executor has certain powers that sort of rank him or her over her siblings or something revolve around family businesses or family real estate. And if there's some question about whether one of the children is going to be taking over the business or buying the real estate out from the siblings and all that, the trustee and the executor have a very pivotal role in helping to figure out how much to incentivize that or how much to make it an open market thing. And And that's the main point at which naming one child may give that child a certain degree of leverage over the other children. Absent something like that, it's certainly efficient to have a single executor rather than two or three of them, because it's just that many more people who have to sign the same pieces of paper that get assets to where they're headed. The sixth point here, where art thou, is just a reminder that as the couple goes through, or as a person goes through these stages of when you get around to doing wills, a lot of times 10, 20 years can go by, so that the period of time between people setting up trusts for their new children and people getting around to redoing things to name their children as executors and such is usually 20, 30 years. And during that time frame, often the law firm that first did the documents 20 or 30 years ago has merged with another law firm, and often that is where the wills are. The wills are one of the relatively few documents that you need the original, and the original is sometimes hard to track down because they can be in law firms that have lost them. It's any one of a number of situations. So that a good thing to do with some regularity is to make sure you can put your hands on the necessary documents that you might have. So we'll go to the beneficiary designations slide. I've mostly talked about wills as the way by which assets pass down to the generation. Wills, beneficiary designations, pay on death designations. You can go to a bank and say, on my death, I want my assets to go to my children. Transfer on death designations is the equivalent for stock accounts. All of those things serve to have all those things serve to get assets to the intended recipient without having to go through probate. Trusts are another way to avoid probate. What probate does is to prove the will to the level necessary for the court to know it was an original will that has been validly signed by a person who is competent, etc. And there's a oversight by a municipal body of some kind that makes sure that everything that the executor does has a check and a balance and is run by the probate court in order to make sure that nobody is up to any funny business. If that oversight is not valuable for a person, avoiding probate by either making sure that everything passes to where it's intended to go by a beneficiary designation or being owned at death already by a trust is always a good thing. Trusts also have the benefit of enabling the trustee, often a family member, sometimes a bank, to step in to manage things even more completely than a power of attorney in the event of incompetency. Once you get into the word trusts, though, there are a lot of kinds of trusts that do a lot of different things. And it would completely derail this conversation to discuss the difference between revocable and irrevocable trusts, or irrevocable. But revocable trusts are a dime a dozen. Everybody, probably should have one if they've got sizable estates, and there's never a downside to them in that they do avoid probate and they get assets to where they're supposed to go. Irrevocable trusts are the tools of those who are inclined toward Medicaid planning and hoping to position their assets in a way that should they become incompetent and have to go to a nursing home, the nursing home is not, may be subsidized to some degree by state money, meaning Medicaid. People often refer to these kinds of trusts as avoiding money going to the state. It's kind of not really accurate. It's just the state is not going to give money to a person who may be going into a nursing home if they have their own money. And irrevocable trusts are a means to try to kind of position your assets as if you don't have assets at all to make it so that the state pays for nursing home costs instead of yourself. There are certainly situations where I recommend heartily to people that they set up irrevocable trusts to plan around Medicaid. Any dire diagnosis that could result in a possibly multi-year, decade-long difficult time in a nursing home can completely financially devastate a couple. Irrevocable trusts are very important in that case. But as a general rule, I'm not of the mind to say everybody should run out and get these irrevocable trusts in order that Medicaid will pay for nursing home costs, or else it's sort of an unfair playing field. So that in my case, at least, as a general practitioner, revocable trusts are pretty much an everyday thing. Irrevocable trusts are reserved for those who I think have unique situations that require them. And there's whole bodies of, there's whole firms dedicated to elder law planning that are probably more oriented towards suggesting that everybody should have an irrevocable trust as a way to, help the state, and ensure that the state will pay for a nursing home cost instead of the person. The last thing that I do try to make an effort to do, my fourth point, is make sure people take a moment to think about charitable giving in their estate plans. It's sort of an easy place to think in terms of a modest gift to places that were important to that person during life. It becomes a reminder of sorts to the executors and anybody else that, and for the purposes of a gift in lieu of flowers type suggestion, possibly the place that was named in the will is a good place for that. And it's on my checklist of things that I do think is important to consider on death. Obviously, I would say probably a third of the people that I work with do eventually have some kind of a charitable inclination. And that's a good segue into the next slide. We've mostly talked so far about assets passing to family members and all that, and there's a lot of misconceptions and remnants of prior law about taxes on death. The word death tax is a loaded word in that it's usually shorthand for a couple of different kinds of taxes depending on which jurisdiction you're talking about, either estate taxes, which is a tax on the estate, or inheritance taxes, which is a tax based on the recipient. Inheritance taxes charge more to distant relatives to receive assets than spouses, for example. But death tax is a broader term, really kind of making the point that this death tax is a fair and an unwholesome thing. The argument has always been, hey, we paid a lot of income taxes to build up our estate, and it's not fair to tax us again on money that we managed to pull together despite the headwind of an income tax. So over the last few decades, the estate tax, the death tax, has really fallen out of consideration for most of the population. Even as an estate planning attorney in Jamestown, Rhode Island, which is that does have a lot of real estate equity and all that, not all that many of my clients have to worry about a 20 or 22 or $23 million tax threshold for the 40% federal estate tax. There was a massive change in the threshold. This is the same threshold that used to be that $600,000 per person thing that kept estate planners busy from 1985, when I started, till 2010, when the threshold gradually worked up from 600 to 750, eventually $1 million. But then it went to 5 million and relatively quickly got up to the $22 million during the last administration. The other significant date is 2025, when that $22 million threshold will revert to 11.5 or so million dollars. So people with potentially more than $11.5 million should remember that by 2025 they're back into the scope of what the estate tax will affect. The other change in the last couple of years really is that the threshold that we're talking about is for a couple. That it's not as though there's a $11 million for one spouse, 11 for the other, and you have to take steps to take advantage of the first spouse's credit in order to use the full 22 million. The full credit is currently portable at the federal level and is accorded to a couple of, to use as they see as necessary. So if they use $1 million on the first death, they've got $21 million, $22 million to use on the second death. There is also an estate tax, my second point, there is an estate tax in 17 states. It's usually just an irksome amount, not a devastating amount. So the federal estate tax is 40%. Most states track the federal allowance for deductions for state estate taxes, and the rate's not going to get much above 10% for most people. It is possible to hit 15%, but that's for the hedge fund managers among us. There are steps that can be taken to, for example, in Rhode Island, our threshold is actually 1.56. It's going to be about 1.6 soon, 1.59. There's steps that you can take to make sure that you use both spouses' $1.59 million to shield a potential, $3.2, $3.3 million. It's worth taking them. Unlike the federal, where you're given a credit for a couple, at the state level, you have to take some steps on the first death to make sure that you use that person's credit, and then you get another credit for the second spouse for the total of $3.2 million. In Rhode Island, that type of planning can save as much as $200,000 of Rhode Island estate taxes if done properly. So it's definitely nice to do. You can save some needless taxes. It's not as big of an issue as had been the 40 or 50% federal estate tax. So long and short of my first couple of points there is that estate taxes aren't really driving estate planning as much as they once did. When the federal estate tax was 50%, we estate planners spent an awful lot of our lives doing tricky things to avoid that because nobody wanted half of their estate to go to the federal government. Now at an 8 or 9% potential state estate tax in less than half of the states, people say, we'll figure those out. And, they don't really structure their entire lives to avoid the tax. In my third point there, myth, lies, and overstatements. A lot of people still, you can say, look, there's zero taxes on your estate. There's nothing, don't worry about it. We're actually, motivated we're often motivated to come up with high valuations for a person's assets on that person's death. And it's still hard for a surviving spouse or the executor to understand that there's no motivation for an estate to be any smaller if it's comfortably below the threshold of, let's say, $1.56 million for the Rhode Island tax. There's no taxes. This is not, none of the money that comes to the family member is further taxed. There's no tax on the transfer. So there's a lot of misunderstandings in the law, and a lot of times people assume that the process of going through the estate administration is going to completely decimate an estate, and these days it usually doesn't. My fourth point on this is that as the federal estate tax has been eliminated, once the threshold is set as high as $22 million, it's really hard to ratchet that back down too far and to affect most folks. I mean, people are kind of like inured to the belief that the federal estate tax is no longer going to apply to most reasonably wealthy people. So there's plenty of talk about other ways to make up for the missing revenue. One of which has been floated, I don't think by Biden, but certainly by some of the other most progressive of the tax people in the Democratic field last year, is to make it so that when a person dies, capital gains on the assets that he or she held will no longer be erased. That right now, because of the possibility of a federal estate tax, there's no capital gains that live on after a person dies. So if a person dies with appreciated securities, the appreciation all goes away. There was talk about repealing that, which would be really a burdensome thing because people would have to try to go back and figure out what they paid for stocks 30 years ago. These days it's not as big of an issue with financial advisors tracking that in your statements and that kind of thing. But still, it was discussed. If that happens, it will be a huge thing for, in honesty, it's going to change a lot of things. One of which is it would make it so that all of a sudden charitable giving becomes a kind of appealing thing, for tax reasons, for self-interested reasons, not just for the, kind of the importance of it. Now, last point about unintended consequences. Because people have certain assumptions about things, they sometimes take steps that are really shooting themselves in the foot. So people do sometimes clear themselves out of assets. They give away their house before death. They do this, that, and the other thing on a kind of a antiquated belief that there's going to be so much expenses on the passing of that death that it's better to get it out to the kids now. So, there are a lot of times where I've come upon a client who already has given away their house to their children. And a lot of times it's not the best outcome for all concerned. With an estate tax as little as, nothing for people below, $1.56 million in Rhode Island, nothing for anybody below $11 million in states like Florida that don't have an estate tax at all. There's sometimes not very much cost for assets staying in the oldest generation through death because there's no real cost of getting that down to the next generation. And to miss out on the current rules that allow for a step up in cost basis was a really big hit. So if you receive a house by a gift prior to death that went from $20,000 to $500,000, you've got $480,000 of capital gains there that's going to be taxed at a number that is magnitudes larger than the relatively small estate tax of having been maintained in the estate. So, it's kind of a pitch for estate planners that don't try this at home. Just make sure any big decisions like that, it's stuff we love to talk about, just run those things by us. So next slide. This isn't, I don't like the label that I gave to this at the end of the day. But it was a segue, it was a continuation of what I was talking about before, which is if it turns out that the step up in basis rules are eliminated and all of a sudden people are inheriting appreciated securities that have capital gains on them. And even more to the point, if a person hasn't spent through his or her retirement plans and is leaving those to the children, those are both burdened assets. They've got taxes that continue even after the death of the person who left those assets, and those become particularly easy assets to consider gifting to charities because that you're really only gifting 2/3 or so of the value if you're giving away an asset that is going to be taxed at 35% anyway. So knowing what assets are in the estate, what the taxes are going to be, does open up some benefits for charitable giving that could be kind of win-win. Life insurance is another thing that if a person has spent their entire life, really worried that they needed the life insurance policy to protect against the unknowns, and then has lived through all those unknowns, life insurance is sometimes a really valuable thing to consider as charitable gift candidate because it's ensuring a situation that didn't come up. And the gifts of real estate was a topic that I was going to cover at some length, but I don't want to get too much in the weeds on that. So move to the next slide.
Yeah, thanks, Eric. I just want to make sure that we save some time for Q&A too, as well. Great brief.
So how are we doing? We 236. Yeah. So really, let's skip this one. And then the last set of documents that I'd mentioned up front that a person takes with them on, as they leave an estate planning lawyer's office is relates to healthcare. And there are, people kind of think of them as living wills. That's the least common. A living will doesn't appoint anybody. A healthcare power of attorney appoints a person to make these decisions. And most states really kind of encourage those. So spouses appoint each other. If the other can't do it, a child acts. There is now a new thing in most states called a MOLST, which is a Memorandum of Life-Sustaining Treatment. That is a healthcare power of attorney that's actually been signed by a doctor that says, hey, this person's towards the end of his life or her life, and if it turns out they're found incompetent on the floor, consider palliative, just comfort care rather than, setting up all kinds of heroic means. And then there's this concept called a HIPAA, where if it turns out you've appointed one person to make a bunch of decisions, but you want all your children to be able to talk to your doctors, you just say, hey, look, the doctor will listen only to my daughter on the big decisions, but all my children can talk to them. So that's the last set of documents that come into that a person leaves with from the estate plan. So sorry to blast through that so quickly, but I did kind of want to warm you up with the questions that might have generated. So if anybody has a question, I think the best thing to do is just pipe in and I'll answer them as they come up.
Good afternoon. This is Marty Minez speaking. The slide that you skipped over, sir, was actually the one that I wanted to see most. So I wanted to show it, please.
This one?
Yes.
So I skipped over. I think I skipped over two in a row. So this one, or
that's the one which most recently, second to last, I think, or the last. Yeah, slide.
One more. So one more down, maybe.
No.
Go two back.
The one before this one right here. Okay, that's good. Thank you.
This one?
Yes.
Okay. This is a interesting one. It could take some time. We did one talk on this not too long ago about charitable gift annuities, and it was a full hour. What all kinds of plan giving take advantage of is the fact that there are actuarial calculations based on what prevailing interest rates are, and define whether or not you get a big deduction by giving assets away in the future, or a bigger deduction by giving the current value of assets away now and then having them pass to children on the future. So we did a whole talk on the fourth point here, charitable gift annuities. Those are a split gift between family members and the charity, where usually it's a couple, or usually it's a single donor who wants a little bit of income and says, I will permanently commit a certain pile of assets to go to the Naval War College Foundation, but I need to receive a 6.5% return for the rest of my life from those assets. And that's a very good opportunity for the foundation. If that person's 70 years old, 6.5% isn't going to devastate, so that's about what the numbers work out to when you go and do one of these things. For somebody that age, if somebody's 80, it's a little bit more than that. If somebody's 55, it's comfortably less than that. But a charitable gift annuity is, for example, you retain the value of the interest through your lifetime, and then the interest goes to the charity on your death. A charitable lead trust, next one up from the bottom, is the flip side of that. It's a person who basically has a good deal of assets, doesn't really need the income from them now, and feels, hey, why don't I give the income from these assets to the charity for the rest of my life, and then when I pass away, it goes to my children who will definitely need this money. Not as common, but those are heavily favored in a low interest rate environment, just the way things work. I'm kind of working up from the bottom towards the top. The other thing that's true is that the IRS has gradually tried to make it easier to make gifts from your IRA to a charity. That's a win-win for the IRS and the world and all that, so that there are some provisions that make that heavily favored. And then the one above that is it's a concept which is periodically it's important to look at a portfolio, and one way you can kind of diversify is if you've made a tremendous amount of value from a particular stock position, that thing has a lot of capital gains on it, and the one entity that can sell that without incurring capital gains is a charity. So that's a good choice for a charitable gift. So that number one would be for a person who, the first bullet there would be for a person who doesn't really need the money anymore and doesn't have children who need the money. Numbers 3 and 4 would be for somebody who wants to retain the value of the gifted asset either for themselves or for their children later. Did that answer any questions?
That's great. With regard to the qualified charitable distribution, point number 2 there, I understand that whatever you give out of your IRA RMD is no longer deductible because it's subtracted from your taxable income. Is that correct?
Yeah, I think that's a pretty good way of summarizing it. Let me restate it another way to see if I'm saying the same thing you are. The main benefit of what had been called an IRA charitable rollover is if in this era, it's no longer worth it for you to itemize, the IRA charitable rollover still allows you to make a gift to the charity that's going to be a benefit to you. You can still use the standard deduction, even if it turns out that it's not worth itemizing for you, and yet take advantage of a gift from an IRA. So it makes it so that you're not forced to itemize in that one situation.
But if you do itemize, I understand you can't double dip and both deduct the value of the charitable distribution and have it eliminated from your income and the rest of the RMD.
Right, correct.
So
gift. Yeah.
So is all of this reconciled then when you file your taxes, or is it done in some way before then?
If I follow your question, you're 100% right that you can't double dip. The transfer from the IRA does count toward your RMD, your required minimum distribution. So if you're required in a particular year to distribute, 5% of your IRA monies, and you choose to make 5% gift to charity, that qualifies for all that. All of it shows up on your tax return, though. I think if it turns out you're doing a IRA charitable rollover, it's going to be shown as it's going to be where you show how you satisfied your distribution requirement. If you do it as a gift of securities, it'll be under the charitable gift section. So anybody, in honesty, if there's a person here who does more tax returns than I do, the mechanics of where that shows up would be, might be something that somebody else in this community knows better than I do.
Okay, thank you.
Any other questions for Eric? Okay, I got 2:45. Pause a little bit more. I know there was a discussion on chat, but it looks like Carla Narowski has with the foundation has answered that. I'll just pause a little bit longer in case somebody else wants to unmute and ask Eric a question.
And actually, what I would encourage people to do is, if they don't have questions, go ahead and thank you for coming. I appreciate you taking the time. But if anybody was thinking, well, I don't want to ask this because it's a really particular question that most people don't care about, and it's just unique to my situation. Feel free to hang on for a couple of minutes and just ask that. So I think a lot of times people are uneasy, sort of, expecting a handful of people to be listening to a question that might be unique to them. But I'm perfectly happy to answer some arcane question for anybody who's got one, and just give everybody else a chance to head for the hills. So,
well, Eric, I have a question. You mentioned at several points insurance as a charitable gift. Would you explain the mechanics of that and whether you think that is a good mechanism for a charitable gift at the end of life?
Well, the main thing that you need to take into consideration is that insurance is tax-free for a lot of things, but it is a part of your estate, and it is subject to an estate tax. So it's just something people sometimes forget about, that they're like, well, what's my net worth or whatever, and insurance is part of that for the purposes of the estate tax. There are two ways you can make sure that it's not a part of your taxable estate. One is to turn over ownership of the policy to a charity. The other is to name the charity as a beneficiary. Compared to the same value, if a person had $100,000 in a life insurance policy and $100,000 in an IRA, and wanted to give $100,000 to family and $100,000 to a charity, you'd give the IRA to the charity because the IRA doesn't have to pay any income taxes on it. The life insurance would be better going to the kids. So it's not the most leveraged type of gift to a charity. I mention it mostly because when people try to think through whether or not they are at or above some tax threshold, they just have to remember not to discount the fact that insurance is a part of your taxable estate, and it could be the thing that pushes you over a threshold, which is a relatively easy thing to fix. It's a beneficiary designation. It's a quick thing. So.
And I would add, this is Carla Narowski, and I'm the president and CDO of the Naval War College Foundation. I would add to that and I think Eric mentioned that the policy itself, the annual premium, is deductible. But another thing that people do is sometimes they have old policies sitting around that they've kind of forgotten about, or they don't need any longer. And so oftentimes people will change the beneficiary on those old policies and gift them to the charity of their choice. So I just wanted to throw that in as well.
And Carla raises a good point, which is the ownership versus beneficiary designation. If you have turned over irretrievably a life insurance policy, for example, just by turning ownership over to a charity, then the premiums that you're paying towards that each year are a deduction because it's money you no longer control. It has already been a gift to charity. If you have a life insurance policy that happens to name a charity as the beneficiary at the moment, and you're paying premiums on it, your ability to change it back to yourself means it's not a completed charitable gift. So it's not that common, but it's a very highly impactful thing to actually turn over a policy to a charity. There have been charities that have really pushed this as a concept. And a lot of times it's colleges that have, 30-year absolutely revered faculty members. And there's been a push to say, hey, why don't we everybody buy a life insurance policy on this person? And they're good. Those are great campaigns. There is always a caution, which is the charities, if they take over life insurance policy, sometimes hesitant to take over the commitment of paying the premiums. So it is definitely an area where different colleges have done different things, and sometimes there's a push to buy life insurance policies on revered professors. And the hope would be that those would be fully funded policies that the charity itself would not have to reach into its own coffers to pay the premiums, because otherwise they got to make a determination each year whether it's worth the investment.
Yes, and if I also may add, what oftentimes institutions do, particularly if your employer is a charity. In other words, is a nonprofit, I should say, and it is aligned with a charity, like the Naval War College is a nonprofit aligned with our foundation, which is a charity. Is oftentimes when the employer offers life insurance through employment, those that either do not necessarily need it or have no heirs, oftentimes they will write the institution's gift receiving arm into as the designated beneficiary on that work policy. So in other words, if you work at the Naval War College and you're offered life insurance and you have no beneficiaries, you might put the Naval War College Foundation in as the beneficiary. It really costs you nothing. You're getting the insurance from your employer anyway. And rather than leave that spot blank, it's always great to think of a charity that you might wish to benefit from in the unforeseen circumstances that you pass while you're employed.
And the one of the reasons that a lot of times there's a movement in an institution to do that is it's nice to be able to tell potential donors from the outside that the donor, that the, you know, in the home team has participated in a particular fundraising thing, so that, you know, if it turns out that a charity can say, hey, you know, 50% of our faculty member are donors to, you know, are committed donors to our planned giving society, that's a kind of an encouraging thing to hear for a potential donor from the outside. And one way to do that is an employee policy like that. And I think actually in the case of the Naval War College, there's a lot of service persons policies that are also good candidates. Those aren't usually big dollar figures, but they're paid up policies that, you know, it's a size of, you know, it's a nice gift. And one of you might know the number, but it you know, it's $5,000, something like that. There's a serviceman's life policies that some vets who served, you know, decades ago carry through life. Anybody familiar with those? So what I don't know is who's still with us, but I do welcome any other.
Marty Menez again. I had difficulty dialing in at the beginning, but are your slides going to be available or posted, or how can we?
Yeah, I'm welcome, and Shannon or Carla or somebody can help get them to you. I will say I'm not proud. I mean, I look at them as I was going through them. I was like, that's a little kind of disjointed. So by all means, the other thing is, any of you really, if it turns out that you have like a specific question, you know, this is sort of my way of giving back a little bit to, you know, I never served, and I do feel, you know, strongly about the Naval War College and the Naval War College Foundation, and feel free to call me or Carla to get to me. And it happens to be the one thing I know about, and you know, it's kind of fun to talk about things you know about. So if you know, in a later time something comes up, feel free to run it by me, and it's something I do for the foundation.
Yes, and we're going to see about if we can make this particular event available to you through a link where you can review the entire event privately to those who have registered for this event, so you can rewatch or go over a certain section if you need to review that section more than another down the line.
That would be great. Thank you. And standing by for the link to do
that. Eric, Phil Wilson.
Phil.
A question. Most of my assets, securities, and real estate are in an irrevocable trust. Do those have to be valued at death for any reason whatsoever?
Well, probably yes, they will be valued, but not for the typical purposes, so that they won't get a step up in basis in most situations. I mean, there's a couple of kinds of irrevocable trusts that were set up to be re-included in a person's estate on death. And the way you do that is what you call, they're called defective grantor trusts. It's a funny name, right? But by design, they're designed to be outside of your estate for as long as you're living, and therefore not attachable for long-term care costs, and yet to be re-included on your estate, in your estate, to get the step up in basis. So they are a part of the, they're an important component of the toolbox of those who are mostly committed to elder law care and figuring out how to position assets to sort of better ensure Medicaid. So if it's that kind of an irrevocable trust, there would be a revaluation.
Can you give me the name of that defective? What is it called? A
defective Grantor trust.
Grantor. Okay.
And the word Grantor trust is the word defective really is the one that's always kind of a mind scratcher or a head scratcher for people. It doesn't serve to get the asset out of the estate is why it's called defective.
Okay.
But it does so intentionally so that it is included in the estate, because for the most part, the estate tax was not the worry. It was, making sure that the asset is not attachable for Medicaid purposes for long-term care costs.
Okay. Understood. Yeah.
But most irrevocable trusts that were designed to get assets out of your estate probably won't get a step up in basis other than that one category.
Yeah. Another question, if you have a moment.
Oh, sure.
The gift of art, but I happen to have a piece of late 19th century art from a fairly well-known artist. Can that be set up in any way in a charitable gift annuity?
Usually not, because it's a hard thing for the recipient to liquidate, to generate the, there might be people who, in a sense would buy it, as almost like it would have to be a choreographed thing where somebody would be the means by which that's turned into money.
Right.
Because a charitable gift annuity is a commitment by a charity to pay a, set amount of money going forward. And charities can't afford to buy artwork unless for some reason it's something that is important to the charity. And gifts of artwork could be a topic itself. If it turns out a charity turns around and sells it in a certain time frame, it has a different tax profile than if a charity takes the artwork and uses it for its purpose of display and whatever else. So the Naval War College Foundation, for example, does receive artifacts for the museum that have an ascertainable value and are a deduction for an estate, and the fact that they actually are putting them on display and rotating them through the museum helps. If it turns out there's any chance a charity would turn around and sell an item of art, they really should tell the donor that they might do that, because it could affect the donor's eventual tax treatment. Same thing with cars and boats.
Thank you.
Sure.
Eric, thanks. I'll end it here. The presentation. Thank you very much for a very informative brief on a complex topic.
It was a bit disjointed, but that is
no, it's good. And we're showing Carla's contact information on a slide, so she would be a terrific POC at the foundation. Of course, she can connect you with Eric for our guests for additional conversation if needed. But this concludes the informational seminar. Thank you for joining us. If you need additional details, obviously Carla's information, but also you can get information off of our Naval War College Foundation webpage at nwcfoundation.giftplans.org. If I could sum up briefly today's presentation, a planned gift is obviously an invaluable way to provide support to the Naval War College and Naval War College Foundation while accommodating your own personal, financial, estate planning, and philanthropic goals. With some detailed research, of course, and planning, you could actually increase the value of your estate and or reduce the tax burden for your heirs. It can also provide you some peace of mind that you've made a significant contribution, if you will, to the safety and security of your family and friends with a planned gift contribution to the foundation. We recommend that you familiarize yourself with various gift options, as Eric has outlined on our webpage, by exploring how to give and what to give, and then compare the gift options and calculate how your planned gift could work for you. We also have available a helpful brochure that we would be happy to mail to you. You just have to reach out to Carla and pass along your information if we don't have it already, and we'll be sure to forward that to you. The Naval War College Foundation staff in its entirety stands ready to support you as needed. So please feel free to reach out to us at any time for any additional advice or counsel. Thank you again for your time and have a wonderful rest of your day.
Thank you, guys.